I'm Chris Burrell, President of the Magic City Bar Association. Thank you so much for joining our Social Distancing CLE series. We've got great information brought to you by great judges and attorneys, and we know that you'll get a lot out of it. The month of August has so many things that we need to acknowledge. From the 100th anniversary of women's suffrage and how that intersects with the right of every American to vote, to the historic nomination of Kamala Harris as Vice President of the United States. There are so many things for us to acknowledge. But we must also acknowledge that August is Black Women's Equal Pay Month. That's the point in the year that a Black woman has to work in order to make the same amount of money as her white male counterparts. What better way to show the absurdity in that disparity than to have the awesome presenters that we have here today. After today's CLE, we need three things from you. 1, use the link in the registration email to submit feedback and attest that you attended the CLE virtually. That way, you'll get credit with the State Bar. 2, if you're not already a member, go to www.magiccityBarAssociation.org and join today. 3, go to Facebook, like our Facebook page, and share it with your friends. Thanks for being here. Have a great day, and we'll now turn it over to our CLE presenters.
Hi, everyone. Here for a practical discussion of civil court practice, and I just wanted to let you know before we start, we will have representatives from the Black app who will be here to make a small presentation right after our segment. So if you'll stay on to hear from Black app. I'm Shera Grant, one of your district court civil judges here in Jefferson County, and I'm glad to be with you today, and I'll let the other two presenters say who they are as well.
Good afternoon, Yawanna McDonald. I'm a partner at Campbell Partners. I've been here in Birmingham, working as an attorney for 7 years.
Good afternoon, I'm Devan Byrd. I'm a trial lawyer at Wynn. I've been here since 2017 when I graduated from the University of Alabama School of Law. And I represent individuals and families that have been devastated by medical professionals, businesses, manufacturers, and individuals at no fault of their own.
Thank you, ladies. So with giving a practical discussion, I'm going to talk about district court since I'm one of the district court judges. Our other district court judges are Judge Cook, Judge Patrick, and Judge Weston Pickens. Many people may not know that Judge Weston Pickens is now one of the district court civil judges after our jurisdictional amount increased. I handle the unlawful detainers, Judge Cook handles the unlawful detainers, and Judge Bentley Patrick handles the unlawful detainers as well, and also any other cases where the matter in controversy is $20,000 or under. Judge Weston Pickens handles driver's license appeals and any of the adults in need of protection and any other cases where the amount in controversy is $20,000 or under. So we have 3 judges that are handling our unlawful detainers, which are the eviction cases. And just to give you a little bit of an update from the district court, not many people are aware, but on September 1st of 2019, our jurisdictional amount increased to $20,000. It was initially $10,000, but now it is $20,000, which is exclusive of interest and costs. That's important for people to know because a lot of people now are filing cases. We have, before the pandemic, we were getting a multitude of cases, of new cases for personal injury cases as well. Now, the case, it can also be removed within 30 days. If the defendant wants to remove it to circuit court, it can be removed in 30 days under section 121230 as well. There have been a lot of impacts with COVID. Of course, it has, wreaked havoc on the entire court system, but I'm happy to say that we are still moving along, and we're doing a lot of cases that are being done virtually. So we have virtual court. The presiding judge has left it in the discretion of each judge as to whether or not they now want to start in-person court. So we do have some judges that are handling in-person court in our district court. But I would say you should check with that judge, that particular judge. For me, I am not handling in-person hearings yet. I'm doing virtual hearings. We are handling virtual hearings as fast as we can. The COVID has impacted the unlawful detainers a very, it's been a great impact on our unlawful detainers. And what we're doing is we're giving those unlawful detainer cases priority. So we're making sure now that we're handling the unlawful detainers with Zoom. And one of the things that we've also done since the COVID impact is we are now putting a computer on the 5th floor by where the Birmingham volunteer lawyers usually sit. We have a computer in that room, and we're setting up a camera. So if there are any pro se clients that do not have virtual capabilities, they're able to come up to the courthouse to hear their case on Zoom with one of the computers that's there. So that's one of the things that we're doing. I also wanted to mention, with regards to our unlawful detainers, this has been a change since 2018, but I'm not sure that a lot of people know, because we get a great many termination notices under section 3598-421. The unlawful detainer portion, if you are evicting for unpaid rent and you're giving a 7-day notice, it has changed. It's been amended to 7 business days. And that has to be in your notice. And a lot of times we're still seeing some of the old notices that talk about just 7 days or 7 calendar days, and that's incorrect. So you will need to make sure that you get the notice that says 7 business days, 7 business days notice.
Okay, so case evaluation. This is going to be the plaintiff's perspective because that's what I do all day, y'all. The most important thing with evaluating a case is, what is the statute of limitations? You've got to know the date, the incident date, because majority of the cases I handle are medical malpractice cases. That is governed by the Alabama Medical Liability Act, which from my perspective is protectionist over the healthcare profession. And with medical malpractice cases, the statute of limitations is actually different based off of the age or time of the medical injury. So for a child where it occurs from birth, at birth, or up till their 2nd birthday, that statute of limitations is going to be different. And so those are all considerations that us as lawyers have to make right off the bat. If you have a car wreck case, you got 2 years to file your liability, but you have 6 on the contract claim against the underinsured, uninsured motorist. So always know your incident date. And with medical malpractice cases, these are extremely difficult to prove. We've got to show that there's a breach of the standard of care, that someone else would have done something differently, and as a result, the individual was either killed or suffered a devastating injury, and that was the direct result of the conduct. And so those are all considerations that are kind of rolling through our heads as we're getting a call in about something that's happened. 95% of what I see, we have to turn down, and it's simply because the bar is so high to be able to prevail, and it is so expensive to pursue these cases. From the plaintiff's perspective, I have to take the client as they are, and these are ordinary people that don't understand the legal system. And so we provide an opportunity for them to understand what happened, to find the truth. We look through the medical records. I work on a team of 5 lawyers that pretty much dedicate majority of our time to just reviewing medical malpractice cases, pursuing medical malpractice cases. We have an in-house nurse practitioner that assists us, and she has not only a background in actual hands-on patient care, she was also worked in risk management for an insurer of the healthcare industry, as well as in a hospital and risk management. Those are perspectives that not a lot of people can provide to individuals on a free basis. We do this for free. We realize that maybe not all of these people are going to have a case, but maybe one day they do have a case. Maybe one day they are on a jury panel, and we want them to have a good impression of us. I know we see a lot of advertisements of, and we think that plaintiffs' lawyers are, chasing bucks or shooting bucks, chasing ambulances, sitting on our gold thrones in our offices, firing out ridiculous demand letters, and that's not what we're doing. We have true empathy and passion for what we do for the people that we have the honor of representing. And it's interesting because COVID has had such an impact where we're working from home and we may not have the ability to bring folks into our office and have a conversation with them in this initial case evaluation stage. And just recently, we actually had a situation where this past Friday, we had a terrible death that occurred last week, and we were able to get them in, sit down and talk with them, show them that we are a team. We are here during COVID. We are here for you. We may have 2 lawyers, a nurse practitioner, a secretary, and a paralegal working on your case, and you can call any of us day or night, text us, email us. We'll respond. We're here for you. We're ready to listen and to work for you and represent your interest. We also use case evaluation as an opportunity to educate people on the conspiracy of silence, that there are affirmative defenses like contributory negligence that you have to be aware of that will just prohibit you from being able to even pursue a claim.
And to add to the case evaluation, I on the business civil side, where I do a number of general business litigation, we look at damages, and we're looking at the breaches of contract or breach of trust, breach of a fiduciary duty. And so you have to evaluate and monitorize what damages did your client experience. And you need to be realistic of that. Oftentimes clients see commercials on TV and they believe that their case is as large as what they saw on TV or what somebody told them. And so it's a point where you have to educate, like Devan said, educate your client on this is what we're going to be up against. You have you have a wonderful case. However, we also have to be realistic about our damages going in. And another thing you need to realize going into it is I don't handle medical malpractice. However, if a client, existing client, business client came to me with some issues and I don't handle that, me knowing Devan, I can refer the case over to her. So get to know your other lawyers where you can be a referral base. Sometimes when a case comes in, it's a good case, but it may take up too much of your resources. You may not have the money, the cash flow to fund the case, especially it's going to be contingency. And so you may want to partner with someone to help you spearhead that case, or you may want to refer it out completely. So know the case when you get it in and evaluate it to see how best to serve that client.
And one thing to add though about people not understanding what they see on TV, there's nothing that shows that there may be a cap, a legislative enabled cap that prevents you from being able to even get damages that are higher than X amount of dollars, $100,000. And we have a duty to be able to tell people that's what, if you come into initial meeting and a lawyer tells you the value of the case, that's probably not a good lawyer, because a good lawyer is going to have a conversation with the client about a value, but what we're doing is we need to be controlling expectations. We've handled trials that are very similar to your case, and this is what the jury thought, or we've settled cases that are very similar, and this is the range. We can revisit this discussion of your case value as we develop the facts. It's so important, though, to control the case from on the front end.
We move the case forward in discovery. Oftentimes I think people believe that discovery is just a waste of time, but it's not. It's time well spent. And you should utilize the discovery period to learn everything you can about your case. Oftentimes I get discovery propounded to my clients, and it's canned discovery, meaning that this is something that the attorney uses in every case. And that shouldn't be so. Each case has specific facts toward it, and you should design your discovery to elicit those facts to get all the information that you can. No one wants to get to trial and have anything surprise, and it's but for you didn't ask for this information, you didn't connect the dots, or you didn't look through the discovery once you received it. You have to make sure you pay attention to that. And I think one thing that's often overlooked is the ability to use requests for admissions. Those you can utilize to elicit facts, get them denied or admitted. And then you can blend those together, have your request for admissions blend into your interrogatories, and your interrogatories should flow down to your request for production. It should all match up and try to get you the best information that you can for your client. You have the use of third-party subpoenas. The only thing to be careful about that is you should put a limit in your subpoena of how much you're willing to pay for those records, because you're liable for the cost of those records. So if the records are going to cost $1,500, you might want to know that on the front end, especially if it's a small case. You might not want to spend that amount of money. So put that disclosure in your request for your subpoena, that if the records cost is going to be over $100, they are to call you first. So it gives you an option to say, wait a minute, let me narrow my subpoena, or that's okay, I don't want to, you don't have to fulfill that subpoena. So make sure you pay attention to that. Devan has had some good advice regarding the FOIA request.
Absolutely. So I use FOIA requests all the time to governmental agencies when I'm in the nursing home cases. You can send a FOIA request to CMS and you can get both the survey information and non-survey information. The same is true sending it to a city or municipality to get information, to get documents and records. I have a case involving a road construction, and so I was able to send FOIA requests to both ALDOT and the city and be able to get documents that didn't even require me to have filed a lawsuit in order to get that information. And that is so important because it goes, circles back sort of to what Yawanna began with, is that, you know, discovery shouldn't be canned. It is an opportunity missed, honestly, if your discoveries can't, just the canned discovery, the boilerplate stuff, because we spend so much time and resources on the front end to have experts lined up and to know exactly what we want in discovery, to tailor that discovery to our specific case. Sure, there are certain things that we may need to and have to request in every case, but there are so many things that when we have discovery limits, interrogatory limits, that you don't want to waste any of those precious questions. I also have a policy of that within a week of getting that discovery, the document productions, I'm reviewing it. I'm putting eyes on it. I'm getting my nurse practitioner to put eyes on it, because I want to then have my dispute letter out, because I know that the defense attorneys have not produced everything that I want. And I'm ready to go, because, you know, then I'm going to be going to Judge Grant saying, hey, I need this, and this is why I have a right to it.
And so in district court, discovery is a little bit different than it is in circuit court. And one of the concerns that the district court judges and I had when the jurisdictional amount increased was we didn't want this to just become all of a court where it's just all about discovery and we're not getting the cases to trial. Pre-COVID, you know, I could set if a complaint was filed, an answer, within 30 days, the case would be set for trial. Well, that's not the case right now, but, and when the jurisdictional amount, but what we typically, and I think you need to really get to know your judge that you're in front of, because different judges do different things. I mean, we try to be as uniform as much as we can, but as the saying goes, that wise people can come to different conclusions on things. And so for me, I don't, the first discovery request that is made, I typically deny in district court and ask that the parties freely exchange information. If they are not able to get everything they need by freely exchanging the information, then I require you to file a second discovery request enlisting what you attempted to do and what you didn't get. And then I will grant the discovery after taking a look at the second. Most of the time, you know, I don't have to grant the second one because it's district court where things are moving very fast. You know, district court moves very fast. And so people are usually freely exchanging the information. And so I think it's important for you to get to know your judge and who you're in front of to see if they will allow the discovery request. Now, if it's a small claims case in district court, small claims, $6,000 and under, then no, we don't give discovery in those cases as well. Those move just as fast as well. So it's important to understand if you're in district court versus circuit court, and even if you're in district court, get to know your judge and how they handle discovery.
One last thing about discovery is that know your deadlines. Typically, circuit court, you have a scheduling order, know when discovery cutoff is going to be. Don't wait till 30 days prior to the discovery cutoff to then send out discovery. Discovery, you can send it along with your complaint. You don't have to wait on that. And so you should be knowing when that deadline is, looking through the discovery like Devan said, and sending out those deficiency letters. Most times you get some discovery and you say, oh wow, I need something else. I didn't ask that question clearly. And be attentive to your responses. A lot of times people use canned responses, objections. There's plenty of case law that says that will bite you. So canned objections are not welcome, and you should really pay attention to those. When the question is objectionable, the request is objectionable, make your objection known. Just don't utilize the same objection throughout your discovery responses. For motion practice, I represent both plaintiffs and defendants, and oftentimes on the plaintiff side, we file our complaint, and shortly after serving someone, you're going to see a 12B6 motion. Those can be for 12B motion can be for lack of subject matter jurisdiction, personal jurisdiction, improper service. 12B6 is famous that, there's failure to state a claim. And so you want to make sure on your complaint that you allege enough sufficient facts in there, especially for personal jurisdiction. You want to make sure you lay those details out on the front end of that complaint so that you could withstand a motion to dismiss. Likewise, on the summary judgment, those discovery, this is where discovery plays into that. If you've gotten sufficient discovery, even with testimony and depositions and affidavits, you can file a motion for summary judgment. In circuit court, you have to wait 30 days if you're the plaintiff before you can file a motion for summary judgment. However, the defendant doesn't have to wait any number of days to file a motion for summary judgment. If you have a simple breach of contract case, if you don't have to go through this exhaustive period of discovery, go ahead and file that motion if it's appropriate. Make sure you utilize those when this can help you advance your client's case. A motion to strike, sometimes a defendant will use a defense that I believe is improper. And so you can file a motion to strike before the court, try to strike that, or a response to something, a pleading or something that they put into the record that it doesn't apply. That rule is there for us to use.
So in district court, we have motion dockets, and motions are very important also for you to use in district court. We get a lot of the 12B motions for summary judgment, motions to strike. I think you should find out from your judge if there is a motion docket or if the motion will be prior to the start of trial. Some judges in district court like to hear the motion for summary judgment. They will set the trial on this date and say, well, we'll hear the motion for summary judgment that day. And if you're unsuccessful, we'll just begin into trial. For me, I put everything on a motion docket. And now before COVID, motion dockets were on Mondays at 9 a.m. But now I'm doing those virtual docket, motion docket. So it's important to find out from your judge, but the motion practice in district court is still very important. We also have we deal with a great number of pro se defendants, individuals that are representing themselves. So we get, especially during this time, we have been inundated with a lot of motion to stop wage garnishments, motion to set aside default judgments. The only thing that I will not set on the motion docket, if your client, if there was a default judgment that was entered on an eviction, an unlawful detainer, and if there is a motion to set aside the default, if it's filed within 7 days, then I will automatically set that aside and set it for trial. If it's a contract or a personal injury case, that was the default judgment was entered. If there is a motion to set it aside within the 14 days before the court loses jurisdiction, then I will automatically set that aside as well. So those are times we don't have to put those on a motion docket. But I would also ask if you have free time. I know we're all so busy, about volunteering with the Volunteer Lawyers Program or doing some pro bono work to help some of the pro se litigants out with their motions, because they're coming into the clerk's office and they're filing motions and they don't know the legal terms that should be used in the motions. And so when their case comes on the motion docket, they're going up against the plaintiff who may have a lawyer and they're not being successful. So if you do have an opportunity to take on a couple of those cases to help out the self-represented litigants, that would be helpful.
Experts. Start early and often with researching your experts. A good expert will, store the value of a case. A bad expert will tank it. And for us specifically with our medical malpractice cases, the Alabama Medical Liability Act sets out specific qualifications for our experts. And with this conspiracy of silence amongst the medical profession, it is difficult and it is rare, few, far between that we can find an Alabama doctor that will testify against another Alabama doctor, same for nurse and all the others in the medical profession. And so we have to go outside and we have to think outside of the box in doing this. A lot of times I'm looking for similar cases using those search terms on Google, Pacer. When I find names or cases, I look at Pacer, or even if it's like a specific product or something to do with a municipality or a Department of Transportation, those sorts of things you can search on LexisNexis and Westlaw, and don't be afraid just to use the good old-fashioned Google. Pick up the phone and call people that do the same work, because we can all be a resource for each other. We also do a lot of medical research, and so you can look at journal articles, other research articles, and don't be afraid to search those authors out and the citations at the end, the authors of those sorts of materials. Those individuals can be very helpful. They can become your expert, and if not, they may be able to direct you to someone that can be your expert. Once I find an individual that I want to look into, though, I, again, run their name through Westlaw, LexisNexis, Pacer, and search them on social media. You never know what's out there, but guess what? The defendants will find it. And I'm so careful. You always have to be so careful with the communication with experts, because all written materials are discoverable. Some say it's a lost art, especially on individuals that are of my generation and younger, to pick up a phone and call people. I love to pick up a phone and call people because you get way more information, and it's not an email that I have to then print out when we have some sort of disconnect or something's lost in translation and now it looks like you're saying something that you're not. Also, video conference, because you don't necessarily know that this individual looks like their very polished, touched up photo that you see on their resume. So I love to video conference with experts, and it's something that my senior partners have become more accustomed to now during COVID, where we do a ton of Zoom meetings, and they are kind of like, wow, we could have done this before. And I'm like, yeah, I know, isn't that pretty cool? So use the technology that exists. I call my clients on FaceTime and just check in with them. Questions, though, to ask experts. I always want to know the number of depositions they've given, the number of times they've testified in trial, whether they've ever been excluded or disqualified from testifying, their hourly rate, because I am not looking to send you a 10,000 page medical record and some policies and some other documents that have been produced in discovery and then get a $25,000 bill. And I'm thinking, oh, wow, I really should have tailored this better. So, you want to know on the front end how much it's going to cost so that you can plan accordingly, because case expenses can add up. And then I also want to know their preferred method of receiving the documents. Some people are okay with digital, others aren't. And so you need to send them paper. But finding those things out on the front end will help you with the headaches on the back end. You know, that we don't have the requirements in state court for these full-on expert reports, and so you need to tell the expert that they may not have done anything in Alabama before. You have to educate your experts just like you educate the client. And again, I do it early and often, researching experts. I may have someone at the beginning of the case when we're evaluating the case that's not the testifying expert, but just the consulting expert. It is okay. And as you get through discovery and you learn more facts in your investigation, then you can kind of change the path that you're going on. These people can help you with your preservation letters, which are so important that they need to go out as soon as you represent the individual or their family, as soon as you have an estate open, and they can then help you tailor your discovery request. And so when you have the expert on board, the person that has the expertise, you don't have to carry that burden, and it can guide you in your case to help control the expenses and control what your volume looks like.
I wanted to also add, for district court, I've seen experts used in district court as well. And I think it's important what Devan said is to please be sure to talk to your expert. Before the pandemic, I had a home rebuilding project that went wrong, and they hired an expert, the plaintiffs, but apparently they did not talk to this expert because he was very, very helpful to the defense. And so make sure that you spend adequate time speaking with your expert if that's the person that you're bringing in court. But experts are used in district court, and they are helpful also on cases where there have been damages in a car. You know, if there's a pro se client where there is a car issue where I took my car to this mechanic, well, you know, it's been very helpful if they could bring in the other mechanic who fixed the car and use them as an expert as well. But experts are helpful.
So when we talk about pre-trial and trial, one step that we did miss here would be mediation and settlement discussion. So hopefully, you know, you've gotten past your summary judgment, or you elected not to file one for whatever reason, and so you're headed to trial. You should take the opportunity to see if you can settle the case. You know, find a mediator, see if you can get the parties to agree to a mediator that is not only going to you know, work both sides of the room, because that's what you need. You need a mediator that's going to push and pull everyone, but someone that's familiar with that type of litigation, that type of case that you're dealing with. For example, I don't deal with or do personal injury, so I wouldn't be the ideal mediator for someone that has a personal injury case. So you should make sure that you get a mediator that knows about the case and has had some kind of experience with that in the past. Get to know your client, talk to your client about mediation beforehand. Don't get to mediation and then, you know, tell your client, well, we have this issue with the case and that issue with the case. Be realistic with your client so that if you can settle the case, fine. If you can't, you move on to pretrial and trial. For pretrial, take it very serious. You know, you have your witness and exhibit list. Don't overlook that. You don't want to get to trial and figure out, oh, I left someone off the list. And then you're begging the other side to allow you to amend your witness list. And you're asking the judge to allow you to amend your witness list, your exhibit list. Utilize your motions in limine properly. If you want to exclude some facts, you want to exclude some witnesses, some testimony, that sort of thing. You want to limit some areas of testimony. Do that. Your motion in limine, what's that used for, so that when you're preparing for trial the weekend before, because trial usually starts on a Monday morning, so your whole weekend is looking at trial documents and preparing, you know, okay, the judge has already ruled on this, so this evidence is not going to be able to come into place. So that's the appropriate time to utilize those motion in limines. Also, your pretrial briefs, you want to be able to tell the judge and have that ready. You know, judgment matter law, if you think you're going to submit that. Have those points and those type of things, a case law that you need. If someone is going to have an objection to some testimony, someone is going to have an objection to you utilizing some type of evidence, have that ready and prepared. In the trial I had in December in Huntsville, opposing counsel, we had fought the good fight before the trial, motion in limines and sort of thing on a particular item, and he brought it up again in the case, an objection. And so, you know, I had that information ready and handed it up to the court. I found additional case law that wasn't previously given to the judge. And so that was very helpful. And it was on the record too, because you want to preserve this when you're in trial, you want to preserve your objections and have that embedded in the record. Devan, do you have any insight on that?
No, you're exactly right. You know, everyone should keep up with what's going on with the law too. It's always changing, and that's why we're lawyers and we love it. The Supreme Court issues orders, new orders, rulings every Friday. Get those, go look at it, get the email and look at it and see. We do monthly meetings in our firm, and we have a law report. I mean, obviously I could write a brief if I needed to, but that's not my best and highest use. And so we have an in-house brief writer and researcher to help us, but that's somebody that's a resource to go to. And I understand that some firms may not have that opportunity. You may be a solo, but keep yourself up to date on the law. And I know we touched on it earlier, but with pre-trial and trial, make sure your scheduling order, you do not let any of those deadlines expire. And one thing I would add is when you're prepping for trial, obviously mediation, yes, so important. We, a lot of times, most of my cases, we write a mediation statement to the mediator that we are not afraid to share with the other side. We're not afraid to give them essentially a playbook to our case because we feel so strongly about the case, because we vetted it and we have expert support and we have focus grouped the case. We focus group it in-house with lawyers, and we focus group it using third-party vendors that can give us a cross-section of our potential venire. And that is so important because we can say, you know, we've sent this case, we've tried these issues to a group of individuals that look just like the people that are going to try this case in a month. And this is what they say about it. And that is some powerful stuff, because you're wanting to arm your mediator to go in there and fight the good fight. When you're selecting a mediator, yes, you want that individual to have the background that you need, but you also want that to be a strong mediator, someone that can deliver the message the way you would deliver it if you were either speaking directly to the party or if you were speaking to a jury. Another thing, I don't know what other people do in mediation, but a lot of times we do an opening statement, and it is our closing argument. It is a preview of a closing argument, and we will take as much time as we need to drill down on whatever we need to drill down. And those are so important to get everybody in the room. You want to have your client there watching because you want them to see you fighting for them, and you want them to be able to see the other side and not view it as such an adversarial situation, because I know a lot of times clients don't understand the law and they are upset by when they show up to maybe trial, and that's the first time that they're really seeing the other side. And at the end of the day of trial, you're talking to the opposing counsel and they're like, well, are you fighting for me? Really? You're friends with them. You're going to have a drink with them afterwards. So you just want to continue to have these conversations and opportunities for your clients to learn that it's really in the best interest of all of us for us to be cordial, friendly, and then when we need to, when it's game time, we put our game face on.
And, you know, before trial or right at the start of trial, you can ask for the clerk to give you a list of the potential jurors. Make sure you ask the clerk the Friday, the week before your trial starts. Call the clerk's office and ask them to give you a list. And then you can look at and see, okay, who am I dealing with? Know what county you're in, right? So Madison County is a engineer, scientific kind of based county. That's a very different jury dynamic than in Jefferson County. So you want to know how you're going to utilize those jurors to your best interest. And so you need to go through the list and look at it. When you are selecting your jurors, you need to be asking questions that are telling them about your case and to see what side they might shape out on. Some people feel, black and white and this is it and there's no gray in between and they're pro plaintiff or pro defendant, you need to know that in the selection process so that you can weed that out. So pay close attention to that. Also, your judgment as a matter of law and your post-trial motions, your judgment as a matter of law that can be raised at the end of the close of evidence. You can raise it again after the judgment is entered. That's under Rule 50. You have 30 days after the entry of judgment to do that. You also have the same 30 days you have to file a motion under Rule 59. It's a motion to alter, amend, or vacate the judgment. Make sure you know your timelines. You don't want to miss that. If you got a judgment that's unfavorable and you feel like you got a wrong call from evidence, from the judge, some rulings, that sort of thing, make sure you utilize the motions that are applicable to that. And that will be under Rule 50, Rule 59.
District court also, I think a couple of things that I wanted to mention, where she said that, the process it doesn't have to be so adversarial. It can still be professional because we are a profession, and we have to remember that we are using mediation for a lot of the personal injury cases, orders to mediate for a lot of the personal injury cases. And it's been seeming to work well. A good number of the cases are being settled that way. And those that are not will be set for trial at a later date. I think it's also important to remember for a district court that your deadlines are different from circuit court. If you wanted to appeal the judgment on an unlawful detainer, well, you only have 7 days on the possession count, but all of your other appeals are within 14 days, which is different from circuit court. So pay attention to the deadlines for district court because they're typically cut in half.
Judge, you have some final thoughts?
Well, a few things, I wanted to say, this has been a trying time for all of us. We're all trying to figure out the new normal. So I think if we're all kind to each other, give everybody a little bit of grace, act in good faith. One of the worst things I think that a judge doesn't want to think that the lawyers are acting in bad faith or lying. I think it's important for us to make sure that we're all in this profession together and to respect the robe and respect others. I had a case not too long ago, a personal injury case where an officer was set to testify and he was subpoenaed. I had my assistant to call him and he just flat out said, yeah, I'm not coming. I'm busy. And so the assistant said, well, Judge, I think you need to just speak to him. I'm going to transfer him to you on the bench. And I said, hey, we're ready for trial. We're waiting on you. He's like, no, I'm not coming. I don't care. It doesn't matter to me. And so that took time out for me. That was just completely unprofessional. I stepped off the bench because I knew this police department's chief and he was in court in 30 minutes. But that was unacceptable. And so let's just make sure that we are still dressing appropriately as well for court. Jackets. I understand we just shouldn't come with our club attire on, and we've all had fun. We've all been to college, and law school was not so fun, but let's just make sure that we're still respecting the bench. And more than anything, be prepared. I know sometimes, things may get past you, but these are your clients and these are very important cases. People are dealing with whether or not they will be put out of their homes, whether or not their bank accounts will be garnished, or whether or not their employment will be garnished. So these are very important times, and you are helping someone who is probably at one of the most vulnerable times. So please be prepared and know your cases. And the last thing that I will say is filing a motion to continue does not mean that it is granted just because it's filed. If you file a motion to continue, wait to see whether or not it has been granted or denied. I can't tell you the number of times I have not ruled on a motion to continue and someone just automatically assumed because they filed it, then I was just going to continue the case. And I'm pretty easy about continuing matters, but when you are the lawyer that the case has been continued 10 times, I'm not so easy about doing that. And so I'm trying to push cases through. And so just make sure that you are prepared and you are waiting to see if the motions are ruled on?
I think we have some time for questions.
One thing I'll add while we're waiting for questions is that, you know, today's a new day. That's something I speak since I've been here at the firm and starting in 2017. And I think since this is focusing on women, it's been a day focusing on women. We need to remember that women need to be inspiring other women. You know, if you haven't, it's so interesting to see when a woman speaks down about another woman in the profession. Men are listening. They are so listening. And it is so important for us not to do it. If we have an issue, we need to go to another woman and to discuss it directly. Women are so often mischaracterized, and it's not the same characterization that is given to a man that when they act in the same way. And so I think it's an opportunity for all of us to continue to inspire and to build up each other. And when I say today's a new day, I also mean that refer cases to young lawyers. I work on a team of four other lawyers. There's 5 of us total. I bring a different perspective than what the other individuals do that have been doing it for 30 and 40 years. And, you know, I'm getting to a point now where they actually will admit, wow, okay, you are bringing a lot of value in bringing perspectives that we didn't even know, think of. I use social media so much to research clients on the front end, so I know what to expect so we can prepare them because I want to protect them. And so we need to refer to baby lawyer, what I call myself baby lawyer, young lawyers. We are not going to be out there on a limb. We will take just as great of care of the client. And what that does is that helps us build a client base, just like the senior partners that I work with, the managing partner has after 42 years of working as a plaintiff's lawyer. So I just want to always encourage people. He tells me, you can't get it unless you ask for it, Devan. So if you have a malpractice case, send it to me. I'll take good care of it, and I will take good care of you. I will remember you. You'll be taken care of, you'll be considered. And I'm always in need of probate lawyers to open up estates. So if you're a probate lawyer, especially a young probate lawyer, send me your contact information and you will go on file for us. If you do plaintiff's work, y'all, I get so many cases that I can't take because I don't specialize in the area. I'm not going to do workers' comp because I can't give the best representation in workers' comp because that's just not what I do day in and day out. So if that's what you do, send me your contact information. I will be glad to send cases because I can't overload myself doing things that I don't necessarily know how to do. Because the Marlins that I'm chasing are big and they take a lot of my time.
I think it's also important for us to, if you've tried a case in front of a judge, you know, after the appeal time has run, ask the judge, go back and talk with them. You know, I feel like we have a pretty good bench here that is amenable to talking with and speaking with other lawyers. Just ask them, you know, what did you think about some of the things I did, the strengths and weaknesses? If you're a young attorney, that's something that I did when I started out practicing. I would always go back and just speak with the judges about what did they think were some of the things I could work on. And I think that will also help and also build rapport with the bench as well. And district court is a great way for young lawyers to begin to practice and to cut their teeth. And so district court is a great place. And I know you may be afraid to try that first case, but if you just get in there and do one case, then things will start to get easier for you. I see we had a question. I'm not sure I quite understood it. Could you retype it for me, Ms. Spear? Someone who was a potential client advised against doing this to avoid proper service. Okay. I'm not sure. Can you retype your question? I don't know if I understand it, unless the other ladies understand it.
Let's see if I can unmute you.
I don't think so.
I don't know if I have permission to unmute you, but I think so the question is, if you get unmuted, okay, there you go.
So basically someone came to me with this issue and they said that they were going to avoid service of process by just avoiding taking the service from the process server. And I was their way of avoiding the case. I tried to explain to them it's a very bad idea because they will eventually serve them correctly. But can you explain, just so I can explain better to people who come to me with that issue, why that is really not a good thing to do in your specific case in your courtroom or when you're working with another attorney, what that does for your case?
Well, in district court, under Rule 4, if you refuse service, if service is refused, if that is the process server that is handing that to you and you refuse service, then all the clerk has to do is mail out service, and then then you're deemed served at that point. So you can't escape service by refusing to take the letter from the process server if they're serving you or someone serving you at your personal residence or where you are. So I think it would be important to tell that person that, you know, once the process server writes refuse service, and typically they'll give a few statements. Once they put that on the return of service, then the clerk will typically mail out service to the address, and then they're deemed served. And within 14 days in district court, you can file for a default judgment.
Yeah, thank you. I was trying to explain that to them, but they believe, and this is something that a lot of people believe, they could just avoid service. And this, I've seen a lot of 12B motions with avoidance or improper service. So a lot of people, even when I'm practicing, like in these small Alabama counties, the attorney will say, well, my client wasn't properly served, and it basically holds up the process. And I've tried to explain multiple times that it's really not an effective measure. It is when you're trying to, avoid being served, but it's not effective in the long run for the judge hearing your case.
Yeah, most times people, are just trying to slow down the case. They think they're buying more time. I actually had a case where I did use it for improper service. And in my case, it was applicable because you can't serve someone else's household. You can't serve a parent for a child, an adult child, just because, oh, that's his mother, so I'm going to serve it on his mother because I can't get to the actual party. And without that person telling the parent that they could accept service for them. So in those types of cases, that is the appropriate motion to use when service is not done properly. But a lot of people do try to use it as a stall tactic and, oh, I'm not going to accept service from the service processor. And, we've had to file affidavits with the service processor attesting to they served this individual, or the individual refused or threw it back at them. We've had that kind of situation, thinking that, hey, they didn't accept service. So you can file an affidavit from your process service showing the attempts that they made to serve that person properly.
Also in district court, we get a lot of motion to set aside the judgments because a good number of people don't know there was a judgment until their wages are garnished. And so I've had a few cases where the process server would say they personally served this person, but they left it in their mailbox when we come to court. And so it's important for you to work hard for your client and to find out, bring that process server in, how did you serve them? Because there have been 3 occasions of the same server where they personally served the person, but what they did was they left it in the mailbox, or they would have left it with somebody who opened the door, but they don't know if that person was of suitable age and discretion, if that person resided there. It could have been a friend that was there and they didn't put that language or find out if that person resided with them. So if you look at Rule 4, Rule 4 will talk about service and make sure that your client was properly served. I can't stress enough because we're dealing in district court with a good number of pro se clients and indigent people that just want somebody to help them on some of the smallest things that I know we're as lawyers, we're looking for that big case, but you will get so much gratification out of helping the people in district court on their motion to stop wage garnishments or their motion to set aside a default judgment, because it may be a $5,000 default judgment that doesn't seem like a lot, but that's a lot of money to someone who who's a single parent with 3 kids and who's also is about to get evicted and lose their home. So just consider that.
I have a quick question dealing with service. Right now with mail being slowed down and everything, and a lot of people being served by certified mail, how is that affecting the court, and how is that affecting defendants on the back end?
Oh yeah, we've had a very big issue because the post office on a lot of the certified mails has been writing COVID-19 on it. And so what we accept in district court, if the certified mail says marked in restricted delivery, which means the person that it's assigned to, if it's me, Shera Grant, I have to sign for it. Or if someone else assigns for it, even though it's marked restricted delivery, they have to sign off as agent. And it's incumbent on the plaintiff to prove that that person was the agent. I have been getting a lot of the certified mail with COVID-19, and then the plaintiffs will file for default judgments. That's not sufficient because COVID-19 is written on the certified mail and not the defendant's signature. So if it's a certified mail, I require that it's marked restricted delivery and signed by the person or their agent with proof that this is the person's agent. Any other questions?
I think that's all. Chris, we'll turn it back over to you.
Thank you all so much. I really appreciate it. Thank you all for being here, Judge Grant, Yawanna, and Devan. You all did an awesome CLE. I was very, very entertained, and I learned a lot from it. The people on this CLE are going to actually get a special treat. I realize that with us being a lot of civil practitioners, people who do wrongful death and civil rights cases and things like that, I think that we have something that's going to be very timely. I was approached by Maureen Martin, who is the CEO of Black App. Black App is a female-owned technology company, and they have a team of Black female IT professionals, and they're on a mission to save lives and address institutional racism with technology. So at this time, I'm going to bring Maureen in, and she's going to give a quick presentation about what they're developing.
Hello all, my name is Brian Wright. I'm a partner to Maureen in Black App. I know she was having some difficulties in accessing the site, so I was going to step in until she arrives, if that's okay.
Oh, hey, I'm
There
here.
she is. Awesome.
Okay. Yeah, Brian, go ahead and start for us, please.
Okay. Well, again, my name is Brian Wright. I was introduced to Maureen earlier this summer and got exposure to Black App. And obviously during the very tragic and heavy summer that we've all gone through, you know, to be quite honest, we know that this isn't new though. And so Maureen introduced a technology that is geared towards protecting Black and brown people from threatening situations that can be essentially prevented from or de-escalated from becoming tragic. And we're, again, seeing this so often. I think a lot of people put in situations where they're faced with, you know, dealing with law enforcement, you know, other kind of racist situations, profiling situations in stores or others, often feel alone, and that can impact how we react in those situations. So Black App is a technology, social safety, focused on building a circle of friends that can be notified at the point that you feel threatened. And then from there, those that circle of friends can receive either a live stream, you know, audio of what's going on at your location. They can know your GPS. And the goal for us, and I know it's been kind of muddled with the whole defund the police, you know, moniker, but I think the goal is we need to have the appropriate first responders showing up at the appropriate times. And I think often we are having armed law enforcement that aren't trained in certain situations, and that's where a lot of these challenges are coming from. So the technology is there to de-escalate not only in our minds, but what's going on, and know that we have backup and people that are listening there to support us and talk us down. But it's also to be able to alert to these other perpetrators that are creating those threatening situations, that they also need to de-escalate and move on. That said, there's also an offline strategy that we'll be employing. And this has a lot to do with what you all have been presenting on the really great panel before us, was really about trying to provide additional information to educate the public on what they don't know. So this could be just from general education to civil and legal information to educate them on what their rights are. And then also to be able to tie into the different community organizations that are there to support us, but we oftentimes don't know those resources are available to us. So Black App will have a portal that will be available to the user base that would be able to amplify Black voices, brown voices in the community, amplify community organizations and other support services, and again, fight the tragic incidents that we are facing on a more frequent basis. Maureen, please step in from there.
Wow, I think you covered a lot of it. Black App is basically ADT, Find My Friends, and Amber Alert. So you would notify your friends and let them know when you're feeling threatened, so they can actually provide the backup for you in real time. And if they can't come, they can send a friend to act on your behalf. The app will be ready in about 3.5 to 4 weeks, and we hope to work with the community to help people feel safe 24/7. And yeah, that's I guess that's a lot of who we are. We're doing a lot with data, which I guess Josie will speak on, in terms of how we're using our data and how data is empowering the work that we're doing to make communities safe for people of color.
If I can introduce Josie to a certain extent. So algorithm equity is an example of a community organization that provides detailed information on police incidents. They use FOIA as a strategy of being able to get information that's usually blocked or shielded from the public on police officers and other law enforcement personnel. And so if she's on, she could feel comfortable coming off mute, but I just wanted to be able to say, like, she's a great example of a group that needs amplification, and we want to provide those data points and other analysis to the community, specifically our corporate and public partners, but really just to educate the community in general.
Yeah, let me just add that we're approaching racism as a mental illness, and sort of dealing with it like you would a pandemic. So we're identifying communities that are suffering from the disease of racism, and sending in peer-to-peer trainers to speak one-on-one with individuals who are involved in activity that's threatening. So if you are a Klan member or an area national person, we connect with members of the community. They could be clergy, they could be mental health workers, to reach out one-on-one and to help people unpack their racism, because we believe that racism, as a racist, it's not a healthy place to spend all your time focusing on how to destroy someone else. So we want them to be well, and to also give them tools so that they know how to interact with people of color in a safe way.
Are there any questions that we might be able to answer?
Sorry, I'm just gonna hop in. Thank you, Brian, for that introduction, and Maureen for the opportunity, to talk about the work that we're doing and the necessity for it. So as they were mentioning, I'm working on this project called Algorithmic Equity that is joined with Black app. And right now, the whole thing is to create a communal knowledge base of specifically the NYPD police officer behavior, which would then be able to be replicated and remodeled in other cities by other developers that would know their cities better. So the whole point is that this is community-based and community-grown, but the data that particularly is being put into algorithmic equity is things like the amount of times a precinct uses force and what type of force they use. So like how many times a precinct uses their guns, how many times they use mesh blankets, OC spray, etc. A count of subject injuries and how seriously the injuries were. So that's from serious injuries, which are classified as broken bones, to hospitalization, to substantial injuries, and a logistical information about the precinct, like the address and the commanding officer, along with the precinct's arrest history, and a section for community involvement, because we want to like kind of give room for trust to be grown between the community and the police department. So we're not taking the police records for full value. We're allowing the community members to kind of have a comment and be like, hey, this person didn't treat me right, this person didn't treat me well, and like put in unofficial complaint records. And that's kind of what Brian was talking about when we are kind of using FOIA requests to grow the database out robustly. So yeah, that's kind of like all the, and you know, also wanting to like narrow in on the demographics of the community. So it's not only like, oh, this precinct is having a lot of police activity, but who exactly are the residents of this precinct? So like community members will be able to see demographic breakdowns like age, sex, race, household type, like a single household with 2-parent household, educational attainment, citizenship status. So all of these things that kind of paint the picture of what a community is, so that people can get a better idea of who this is affecting. That's all I would have to say.
Well, and just so that's the power of the technology. So, I mean, kudos to Maureen for coming up with this, and Josie. I mean, the point about the data and analytics is to be able to, one, encapsulate and build a knowledge base to educate all of us ongoing. But I think what's critical as far as technology points is being able to build like heat maps of these incidents, so people are more aware of where safe zones are and non-safe zones are. If they are running into issues of bad service, or in the workplace issues or other, this could almost serve as a Black Yelp or a Black Glassdoor. But the key is putting our own people to work on building that analysis, because so often, although Pew Research Center and others have some of this data, those reports aren't often done by us. And so this app is for us, by us. I think some synergies with your group overall would be, one, for you, for your staff, for your clients in particular. So, I feel like it's an amazing tool. This summer could not be it's the worst example, but it exemplifies why we need something like this, and we can't wait on other people to do this analysis and support for us.
Well, thanks so much to the Black App team, for Maureen and her team for joining us to share the information that they've shared with us concerning the Black App. We certainly look forward to hearing more about it and how it's going to revolutionize the way that we help protect our citizens. I want to once again thank Judge Shera Grant, as well as Devan, Byrd, and Yawanna McDonald for an awesome CLE. I want to thank everyone for attending this afternoon, and you'll be hearing more from us pretty soon. Thanks again for attending. Everyone have a great day.
Thank you.